So, firstly, wish to congratulate the organisers for being really ambitious here, or maybe having a good sense of humour in expecting a lawyer to talk about all the risks facing landfills in just 20 minutes, and putting me in the afternoon slot just before you guys head off to drink and expecting you not to fall asleep. Admittedly, I was tempted to put my cowboy hat on and boots early to keep it interesting, but I promise by the end of it, you'll all be so fascinated by the legal risks you face with landfills. You'll agree with me that it's a fascinating area. Okay, that wasn't a joke. What I'm going to do is just give you a really high-level overview of the legal risks faced in the life cycle of a landfill, simply because there's not a lot of time, and I want to keep it relevant nationally. First phase is the approvals phase. In the previous session, David spoke about David from GHD spoke about planning approvals, and in each jurisdiction, it's a really complicated process. The planning approvals is really the thing that can stymie your project for landfill as well as other waste infrastructure. Generally, if you get your planning approval, the other phases, the environmental approvals and other related approvals, flow a lot easier from there. With the planning approval, the first step is identifying what approval you need. In most jurisdictions, there are various paths. Some can be state significant, so you go to the state government, some local government, and there's a whole range of things in that which I won't go to. Each state has a different name. In Victoria, a planning permit, New South Wales development consent or state significant development, etc. But it's relatively the same thing in most jurisdictions. And there may be a whole load of other ins and outs to the process in terms of your zoning, whether you need to change the zoning, enter into some kind of planning agreement, infrastructure agreement with the local government or the state government. Needless to say, it can be a lengthy process, anywhere from 12 months to 3 years for these sorts of facilities. And the key risk there is obviously time. If timing's critical, that can really hold your project up. We see a lot of prosecutions in this area in terms of smaller players who probably should be licensed as a landfill. I say smaller players, really illegitimate players, people who are carrying out activities which are akin to landfilling and don't have planning approval or an environmental approval to operate as a landfill. Examples, particularly with construction demolition waste, using that C&D waste to construct something to fill whatever it is. Wallandillion, Foxman, EPA and Hart are examples in New South Wales. But typically, you would think people generally should have known that they needed those planning approvals. The other thing to note is, some of those projects have a very long lifespan, and what you get approval for now may not be what's going into that landfill 20 years from now. It may be radically different. So the more you can scope up front, the broader approval you can get, the better off you are, the less you'll need to modify it and go through the process again further down the line. John spoke about urbanisation. Obviously the biggest issue facing the planning process is where to put it, and really I don't have a lot of solutions to that. So the main part of my talk today, once you've got your landfill up and running, it's not all smooth sailing. There's some operational risks you face. Just a small taste there. In terms of the approvals, obviously breaching your approval conditions. In my experience, the cases I've been involved in, the breaches often occur, where operators don't have the capacity in terms of staffing and systems really to deal adequately with that. You're talking particularly smaller local government players who don't have the sort of 24-hour staff and operations that a larger player like Suez would have. And particularly, a lot of breaches occur where there are contractors, subcontractors, employees, whoever it is, who aren't properly inducted and don't actually know what the relevant conditions are of the approval that they need to comply with, because those conditions somehow haven't made it from the consent or approval into the environmental management system or operational management plan or whatever document it is you have in place, and they're not aware of those, so naturally they may breach them. So that's really one of the biggest dangers with approvals, is making sure everyone on site, particularly in an operations role, knows what they have to comply with in terms of their approval. Pollution is a big one, obviously headline grabbing because it has the largest impact on the public, on the environment, and that's where you see a lot of prosecutions. Again, a lot of the time, most of the time, these aren't willful issues, they're operational issues. I'll go into a couple of examples of prosecutions which will show you how these incidents have occurred. Duty to report, a number of jurisdictions have a requirement where you have to effectively dob yourself into the regulator when an incident occurs, which is, again, in the interest of the community and the environment, but obviously not terribly in the interest of an operator who might get in trouble as a result. The contamination, you're really dealing with a more long-term insidious issue as opposed to pollution, which is often quite immediate. Above ground contamination, typically more below ground, longer term, and you're talking about leachate going into groundwater, and that's a really insidious one, because often you can't accurately quantify what those liabilities are long term. It might be the case that you took over a facility from a previous operator, and if you haven't accurately quantified what's below the ground, what the risks of remediation are, and particularly if it's gone into groundwater, etc., there can be huge remediation costs involved, and that liability can follow you even if you sell the site to someone else. In most jurisdictions, the laws are such that the polluter pays, so that can catch you years, decades down the track. And migration, obviously this isn't some kind of xenophobic message. I'm talking about groundwater migration to other sites, because that then brings in issues of common law liability, nuisance negligence to your neighbours. And I've got a matter at the moment which has been through years of litigation, millions of dollars spent in legal fees where there's cross-contamination between sites, and it's quite a mess. Regulation, New South Wales, the recent, the new regs which came in November, are a perfect example of how that regulatory risk can change things. Not so much for landfills, really. That's probably going to have a bigger impact on transfer station and other facilities, but in dropping the licensing requirements, requiring weigh bridges, etc., the waste levy being assessed up front for a lot of those interim facilities, that can increase costs quite significantly on operators in a way that no one really anticipated. So those regulatory risks have to be kept in mind, as well as all the compliance costs, etc. Things like waste tracking, interstate, and of course offences relating to false and misleading information again. Something else to note, in most jurisdictions, directors and managers of companies are held to be liable for offences committed by the company. So again, that's a risk within the company, and a reason that it's in management's interest, not just the operational people or the legal people, but it's really the management who need to make sure from the top down that the systems are tip-top and that everything's above board, because it could be them personally on the line as well as the company. So you didn't think I was finished in terms of operational risks, I hope. Asbestos, we all know that's obviously a pretty serious risk, not just from an environmental laws point of view, but workplace health and safety. And then contracts and others, the management of contractors and subcontractors, I already mentioned briefing them, etc., but the arrangements that you have with contractors and subcontractors, often in terms of prosecutions and breaches, there can be contractors involved in whatever the issue was, and being very clear about chain of command, who has responsibilities can make those, minimise the danger of those things occurring, and then if something does happen, a lot easier to deal with, because inevitably in a prosecution where contractors or subcontractors involved, people start pointing the finger at each other, and it becomes quite clear that people didn't quite understand who had responsibility for certain aspects of operations or of a project. Pricing in council contracts, this is one I've had a lot of fun with over the years, and I've acted on both sides, I should say. It's very hard to anticipate what's going to happen. These council contracts are typically 7 to 14 years or so, and waste streams change, operations change, all sorts of things change, and the pricing, changes along the line, regulations change, etc. So having, often councils just go out, trot out the tender, fairly similar to what they did 7 years ago or whatever it is, and don't really put in the time and thought as to how those rise and fall pricing mechanisms, or CPI or whatever, how you work in different adjustments into the pricing, KPIs, and those can lead to problems down the line. I've been involved in litigation where pricing's been a big issue, and I can't tell you how spending a bit more time up front in really thinking about how those pricing mechanisms are drafted in contracts can save hundreds of thousands in legal fees further down the track. I mean, don't get me wrong, very happy to sort it out for, enormous amounts of money down the end, but it's not in your interest. So I'd invite you to put the time in up front. And also in those contracts, the other thing is dispute resolution. Often no one thinks about those clauses because they never believe they'll enter into a dispute. But, over 10 years or so, there's a good chance something will come up which you may not agree on. So thinking about those dispute resolution mechanisms and a practical way of resolving them, putting that into your contract is also a good idea. Nuisance negligence, there have been a few cases around the country. I'll talk about one in a little bit. And finally, others, valuation's an interesting one. Talking about, there's a case we had recently for a client in New South Wales where the Valuer General had a policy for land tax and rating purposes of not taking into account contamination in land value. So they assessed our client's site as being worth $7 million because we assessed it at being worth $0 because it was heavily contaminated and the remediation costs were quite enormous. We were successful. The VG's, this is only a few weeks ago, the VG's policy has now been overturned by that case. And so for all of you out there with assets, with waste facilities that might be heavily contaminated, it is worth looking at those valuations. Next thing is community engagement. There's nothing that can put pressure on the regulator to take action like community pressure. I can see some of you are smiling. I wonder who in this room might have been involved in some of these. But that's not to put blame on anyone, but the community pressure can be an enormous driver for regulatory action. And so, leads to the next step, more than anything else, I think, other than a dramatic pollution incident, which is involvement with the regulator. Now, I have to admit, with a country western theme, I was tempted to go with that throughout my presentation. At this point, put up a sort of EPA officers with a sheriff badge, but got a couple of clients who in a sensitive position at the moment, so I thought better of it. Better not test the sense of humour with that. But the regulator's got a very important position in this whole process, and you have to be very careful and deliberate about how you deal with them because they have a broad range of powers. They can require interviews, documents, etc. But at the same time, and they have a large range of tools in their arsenal. So I'll talk in a second about how to deal with them. But while the headlines are grabbed by prosecutions, big fines, etc., generally speaking, they have a lot of softer tools in their arsenal, and as long as they don't believe you're trying to pull the wool over their eyes, or you're not sort of egregious or willful in your conduct, more often than not, the EPA and the regulators across the country engage rather in terms of education, warnings, pollution reduction programs on your environmental license. We've had a number of times we've avoided prosecutions by enforceable undertakings which achieve positive environmental outcomes because you are required to undertake certain environmental works or whatever it is, improve your processes. It's good for you because it may decrease costs, etc. But at the same token, it's good for the regulator and the community. So they do have a lot of tools in their arsenals, fines, warning letters, notices to do various things. And then in terms of how you engage with the regulator, it's incredibly important to be proactive and work with them as much as you can. I can't tell you how, if the regulator thinks you're hiding something or trying to sort of sweep something under the rug, that's when they go after you, and that's when they really come down heavy on you. It can take years to build up that trust and one incident to get rid of it. So that's the most important message in terms of dealing with the regulator. It's also really important though, I'm not saying it's not a confessional at the church. You don't have to go and confess all your sins unless you have a duty to report. You should also be careful in how you deal with them, and to that end, having clear lines of communication. It's no use if you've got one person sending one message, someone else dealing with a different officer and sending inconsistent messages. So having that sort of communication protocol is very important as well. I won't go through these in detail. Suffice it to say, there's a lot of smaller operators who've been prosecuted in the past. Typically they don't have the resources of the larger players. The risks primarily are technical issues, lack of good management systems in place. So for example, the Greater Taree case was poor maintenance on a leachate disposal pipe, so the temporary clamp failed and leachate streamed down. Similarly, the Port Stephens, the waste and recycling one was discharge of leachate. Port Stephens one was an interesting one. I talked earlier about your approvals covering what you're doing. This was simply a case where over decades they hadn't updated their approvals and in fact got prosecuted for lack of an environment protection license. But the big lesson in terms of the prosecutions is keeping those technical issues under control and also remembering it's a criminal offence. Another interesting one, Whelan and Casey. This is down in Victoria. Loads of defendants, pretty much every law firm in Victoria within environmental practice was involved, and it was actually a class action regarding the migration of landfill gas from a former landfill. And that one is really squarely about the urbanisation, how that can impact on landfills and former landfills. Because years ago that site might have been fine, but as residences encroached, those odour issues became a lot more acute. Finally, closure and renewal. John also discussed, there are enormous liabilities if it's not done properly. However, at the same time, with property prices where they are, there's enormous potential for redevelopment of sites if done properly. The key message I'll say on this is to make sure your indemnities and contract clauses are absolutely watertight, because otherwise that liability can follow you years, even decades down the track, and be millions of dollars. So those contracts have to be absolutely watertight before you redevelop and sell a site. So that's about it from me. I think I'm out of time, so I won't open it to questions, but if you've got any questions, feel free tonight to ask me. Probably your only chance to do it without the 6-minute clock ticking, and probably your only chance to ask a lawyer wearing a cowboy hat and boots some questions as well. So that's about it.
Thanks, Gavin.